Academy's YouTube channel. Guys, today we are going to quickly talk about the objections to the provisional answer key for CLAT PG 2024. It's going to be a very short video. So CLAT had released an answer key and then they had taken it down, and yesterday evening they have uploaded a new one. So these objections are according to that. So do watch this video and see if you have to even raise objections for any answers or not, right? Now, our solutions are as per the set A of CLAT PG paper. So make sure whenever you are looking at the answers, it is as per either set A or look at the questions carefully, right? So now first disclaimer is this, that the answer key seems to be correct, right? There isn't much scope for you guys to object to it because as per our research, the answer key actually does look correct. However, there could be certain areas which are a little subjective, and for that a lot of students have questions whether they should raise objections or not. So in this video, I will particularly be talking about those doubtful areas where you are not sure if you should be raising an objection because you have very less time, only till 7 p.m. today, to actually raise objections, right? So I'll be taking a few questions one by one to tell you if you should go for it or not. The first question for which many candidates are having difficulty is question number 16 for set A, which is about the decision in Sri Sidbali Steel's case. Right now, the passage is not very clear on the answer. Even if you read this judgment, you'll not get very clear. Okay. However, this judgment does talk about fiscal matters, but there is no general understanding as to when does the Supreme Court apply the public interest exception in promissory estoppel cases. Right. So many students feel that the right answer should be all of the above. It should be fiscal, labor and service matters, but again there is no evidence to it, right? Like if you are raising an objection, you will also have to give some evidence for it. So as per this judgment, if we just read this case, then this case does talk about fiscal matters. So as per the answer key, they have marked the answer as option A. So I will suggest not to raise this objection because you will not have any concrete evidence for the last option, which is all of the above. So let this one be. Now coming to the next doubtful area, people are having difficulty with this jurisprudence question as well, which is about legal moralism, as to what is the under legal moralism, what is the primary role of law. So many students feel that primary role of law should be option A, which is protecting individual rights and maintaining social order. That being correct, the answer has to be as per legal moralism alone. So if you read the passage also, you will understand that as per legal moralism, imposing moral values is the primary role of law. So the answer in the key is correct. Coming to next question. So these questions are from family law area. Now family law ka one passage came which was very subjective, right? Like there is no objective answer to it because answers will be based on our understanding of the passage, which can be a little subjective. So if you look at question number 72, which is from the judgment quoted in the passage itself, many students feel that option A can also be the right answer, but the answer key has marked option B as the right answer. Similarly, for 73 also you can see that students feel that option B and C can also be the right answers. We will suggest that you should not raise objections to these questions as well because it is likely that it will not succeed. It's not to say that what CLAT has given is actually correct, but the thing is that since it is based on interpretation of the passage, you'll not be able to prove that what you have marked is actually more correct than what they have provided. So in questions like these, there will always be a possibility that one form of interpretation is preferred over the other. So we will not suggest you to raise objections for 72 or 73 either. Same applies for the last two questions on this passage, which are again from the interpretation of the passage itself, right? So the same reason applies here also, that even if you feel that you are deriving this conclusion from the passage and CLAT has chosen some other conclusion which is also equally correct, so again your challenge may not be successful for the lack of any evidence because interpretation is very subjective, right? Now this is the last question. This is from the specific performance contract passage that was given. Now many people feel that option B and C are correct and that is why option D should be the right answer. However, in September 2023, there was a recent judgment by Delhi High Court which had actually clarified that now after the 2018 amendment, specific performance of a contract is a general remedy. And if we look at option B and C, they are actually about the part performance of a contract. So actually the right answer should be option A, which is correctly marked in your answer key. So overall the thing is that new provisional answer key which they had released yesterday evening actually seems to be correct. However, there are certain grey areas where interpretation is involved, but we will suggest that not to challenge those questions and save your money. overall, we feel that the paper was good. If you have any other insights, if you think there is some other answer which you think is wrong, do let us know in the comment section. All the best, guys, and do let us know how well you have scored.